In this lesson, we're continuing our discussion of witnesses and testimonial evidence. Specifically, we want to focus on impeachment under the federal rules of evidence. Of course, impeachment simply refers to attacking a witness's credibility. This is often the bedrock of an attorney's cross-examination of a witness. For example, say that a witness gets on the stand and says something that goes against your case. Imagine that a witness gets on the stand, points directly at your client and says it's him, he did it, he's guilty of this. Right? Well, on cross-examination, what are you going to want to do with this witness? This witness has just pointed the finger at your client and said, your client did this, right? I saw him do it. Well, what do you do on cross-examination with that witness? Obviously, right, you have to discredit the witness. You have to say, look, this witness isn't to be believed. He lacks credibility as a witness. This is called impeachment, right? And we have 4 up here on the board for our purposes on an evidence fact pattern under the federal rules of evidence. These are the big 4 we want to think about, right? We have bias, sensory defects, prior inconsistent statements, untruthful character. So in that example, right, witness takes the stand and says, I saw it, it was your client, he did it, he's guilty. Right, well, what do? Well, hey, on cross-examination, right, this witness is biased. This witness got a plea deal from the prosecution. Of course he's going to testify that my client did it. He has bias. Or this witness doesn't know what he saw. It was late at night. There was no lights on. It was 100 yards away. He has blurry vision. Sensory defects, right? He couldn't see. He doesn't know. Right? You're attacking the witness's credibility. Or prior inconsistent statements. Hey, look, this witness's story has changed quite a bit. From 3 weeks ago, from 6 months ago, to today. Right? This witness's story is all over the place. We have so many inconsistencies here. We're not to trust this witness, right? What's up with all of these inconsistencies? Prior inconsistent statements, another way to attack the witness's credibility. Also, untruthful character, right? We're not to believe this witness. This witness is a known cheater, fraudster. He's a deceitful person. We can't take a word that he says seriously today at court, right? All of that is a way of attacking the witness's credibility. Again, that's why this is often the bedrock of the cross-examination of a witness. You generally, as an attorney, are often going to want to discredit what a witness is saying. The mechanism that you use to do this, we refer to as impeachment. So we're going to focus on these in this lesson, right? These are the big 4 for our purposes under the federal rules on an evidence fact pattern we really want to think about, right? Bias, sensory defects, prior inconsistent statements, and untruthful character. But before we start jumping into the details and exactly how you can attack a witness's credibility and how you can't, there's a couple little introductory concepts that we want to go over, right? First, I think the best place to start is just with some simple timing issues, right? So it's important to recognize that with impeachment, we're referring to attacking a witness's credibility. But when are you allowed to support a witness's credibility, right? Well, the federal rules of evidence tell us that you can't bolster a witness's credibility. In other words, you can't support a witness's credibility until it has been attacked, right? Once impeachment of a witness has happened, then you're allowed to rehabilitate the witness's credibility. But you can't support the witness's credibility unless their credibility has first been attacked. So bolstering, right, you're not allowed to do this. At this point, you can't support a witness's credibility until it has been attacked. Just one thing you want to look out for that's commonly tested on evidence fact patterns, right? Again, the only difference between bolstering and rehabilitation is the timing, right? You're allowed to rehabilitate once impeachment has occurred. You can't bolster, right, before impeachment has occurred, right? So you got to identify, are we supporting the witness's credibility or are we attacking it, right? If we're supporting the witness's credibility, we're not allowed to do that until after impeachment has occurred, until after the witness's credibility has been attacked. Similar to this is the idea of 607, which we don't have here on the board, but I'm just now thinking of, right? We have Rule 607, which is going to deal with who may attack the witness's credibility. It's very simple, right? This is one of those one-sentence rules under the federal rules. Important for us to recognize, though, before we jump into this, that both parties are allowed to impeach a witness. Obviously, when we're thinking about impeachment, we're typically thinking about cross-examination of a witness, but it is important for us to recognize that you are allowed, under Rule 607 of the Federal Rules of Evidence, you are allowed to impeach your own witness. You can attack your own witness's credibility. Many of you might be wondering, why in the world would you ever want to attack your own witness's credibility? Right? I don't want to get into all of the strategy involved here, but there are strategic reasons you might want to do this. The first that comes to mind is in a situation where the whole courtroom knows that there's a credibility issue with your witness, right? The jury knows it, opposing counsel knows it, you know it. You might want to address it before your witness gets hammered on cross-examination, maybe to take the wind out of the sails of the cross-examination, maybe just to build rapport with the jury and put it out there, but also to give your witness an opportunity to shed some light on this credibility issue. And you're allowed to do that, right? You can impeach your own witness. So if there's a big credibility issue and you just want to come out with it and address it, you can attack the witness's credibility. Once you do that, right, then what can happen? You can start to begin the rehabilitation process. Hey, look, we know there's a credibility issue here, but this is why it's not a big issue, right? So there's some strategic reasons that you might want to impeach your own witness. But again, 99% of 9 times out of 10, right, when we're thinking about impeachment, we're thinking about cross-examination, opposing counsel discrediting a witness, right? So that kind of goes with timing and this idea of rehabilitation. The other point we want to think about, right, and this is kind of our gateway issue on an evidence fact pattern. Before we start jumping into the analysis, right, of any of these different methods or forms of impeachment, one of the most important things to do is identify the source of the impeachment, right? We want to look at how we're attacking this witness's credibility, and we want to ask, is this extrinsic evidence or is this not extrinsic evidence? What is the source of this impeachment? Are we going directly to the witness? Is this happening, this attack on the witness's credibility? Is this being done on cross-examination to the witness, or are we bringing this in from another source, right? If it's coming from any other source but the witness being impeached, we call it extrinsic evidence. It's important to note this because in some situations, we'll see as we go through this, that to introduce extrinsic evidence to impeach a witness, you must first lay a proper foundation. So you have to lay a proper foundation before you can attack a witness's credibility with extrinsic evidence, right? Using another source other than the witness himself to attack the witness's credibility. It could be calling your own character evidence, bringing in some other type from another source, though, to attack that credibility, right? That's called extrinsic evidence. Important to recognize that sometimes, in order to bring in extrinsic evidence to attack a witness's credibility, you must first lay a proper foundation. So that's why on an evidence fact pattern, really our gateway issue is, number one, we want to identify, is this extrinsic evidence or is this not extrinsic evidence? And the easy way to remember this is, if it's on cross-examination, we're getting this impeachment straight to the source, right? We're getting it on that cross-examination where this witness has the opportunity to explain the situation, to explain the credibility issue, right? That's not extrinsic. It's coming straight from the source. But if we're getting this impeachment from another source, right, that's called extrinsic evidence. And a lot of times we want to make sure that we've laid a proper foundation before we do that, or we're required to under the federal rules, right? And again, the idea here is that sometimes we want to give a witness the opportunity to shed light on the credibility issue. That's what we're talking about when we're referring to laying a foundation. We want to give this witness, if we're going to attack their credibility, an opportunity to explain this credibility issue, to shed some light on it, right? Lay the foundation before we just bring it in from another source, right? So if we never lay a foundation, we just call some other witness to come give their opinion about it, and the witness who's being attacked is having their credibility attacked, never has the opportunity to explain themselves, right? Sometimes we'll see that the federal rules is going to preclude that, right? And that's what we're talking about when we're referring to laying the foundation and extrinsic evidence, because you're going to hear me use those words interchangeably a lot. That's what I'm talking about, right? So step one on an impeachment analysis, we do want to make sure we know the source of the evidence. Is this extrinsic evidence or is this not being used to impeach the witness? Okay, with that, I think we're ready to start jumping into these different forms or methods of impeachment. We can start with bias and sensory defects. What's interesting about bias and sensory defects, just a note here, is that we don't have any federal rules in the federal rules of evidence dedicated specifically to these two forms of impeachment, right? This is mostly coming from case law. So we're diverting a little bit from the federal rules of evidence, but there is well-established case law here for us to rely on. So again, that's with bias and sensory defects, right? And then we'll jump into actual black letter federal rules when we get to prior inconsistent statements and untruthful character. Okay, so what does the case law say about bias and sensory defects? Now, important to recognize too, just one other note before I jump into it to be completely clear, the federal rules does reference bias and sensory defects in different parts. What I'm referring to is that there's no rule actually dedicated specifically to bias and sensory defects as methods of impeachment like we have for prior inconsistent statements and untruthful character. Okay, but enough with that, right? Let's jump into bias, which does come from United States v. Abel, which lets us know basically that bias is a valid form in which to impeach a witness. And so even though here that we don't have a federal rule that explicitly states that we have to lay a foundation to introduce evidence of extrinsic evidence of bias, most jurisdictions do require that a foundation be laid on cross-examination before extrinsic evidence of bias is admissible, right? And of course, bias, again, is referring to where we're attacking a witness's credibility either because they have a relationship with a party to the action or they have a stake in the outcome of the action, right? So the example I used earlier is a classic where a witness who has already gotten a deal from the prosecution is testifying on the prosecution's behalf, right? Well, that witness might have some bias. You would see this oftentimes in an employer-employee relationship, right? Any type of agency-principal relationship, right? Or if someone has a financial outcome in the stake of the action, right? You know, there could be a million different ways that could be, right? Someone is motivated by the outcome of the lawsuit. They're going to get some benefit if this lawsuit goes one way or the other, right? That could affect their testimony, right? They have bias. So again, really the two forms of bias are either going to be because the witness has a relationship with one of the parties to the lawsuit, right? It could be familial too. Someone's mom is testifying on their behalf, right? A person's mother probably has some bias, right? And also a party or a witness that has something at stake in the outcome of the lawsuit. Usually it's some sort of financial stake in the outcome of the lawsuit, right? Then they might have some bias there. Okay? And so again here, the first thing we want to think about with bias, like we mentioned before, is, okay, what's the source of this impeachment? Is this happening on cross-examination, or is this happening through extrinsic evidence, through some other source than the witness himself? Right? Because our rule is, even though the federal rules don't explicitly state that we have to lay a foundation before introducing extrinsic evidence, most jurisdictions, we know from the case law, most jurisdictions require that a foundation be laid on cross-examination before extrinsic evidence of bias is going to be admissible. So in other words, right, in order to bring in extrinsic evidence of bias, the witness, right, whose credibility we're attacking has to first be questioned about the bias, right? They have to have the opportunity on cross-examination to explain or deny this bias, right? They have to be given the opportunity to shed some light on the bias. If that happens on cross-examination, then we're going to allow extrinsic evidence to come in also on the bias as well from another source, right? So that's just kind of the procedure that we want to look out for with bias. Just recognize that if somebody's calling another witness to come talk about this witness's bias, right, you then have to ask, well, that's extrinsic evidence, right? Was the witness who's getting their bias credibility attacked given the opportunity to explain the bias on cross-examination? If not, then no extrinsic evidence of the bias is going to be admissible. All right, so with bias in most jurisdictions, right, that foundation has to be laid by cross-examining the witness and attacking their credibility and giving the witness the chance to explain that bias. That has to happen, right? That process of laying the foundation has to happen before we're going to be able to bring in extrinsic evidence to attack this witness's bias, okay? Now we can compare that with sensory defects, right? Because sensory defects we'll see is a little bit different or completely different, right? Sensory defects refers to where we're attacking a witness's credibility based on we're attacking the witness's credibility because we're saying they have some sort of inhibited ability to observe, recall, or relate information accurately, right? They have problems with their vision, their hearing, right? Or it could be memory defects, right? Something happened a long time ago, or they have early onset Alzheimer's, right? Anything that goes to their mental competence, anything also that would be related to their five senses that might affect their testimony, right? Hearing problems, vision problems. It also could be just things that were out external forces that affected their ability to observe, recall, or relate information, right? It was late at night, it was dark, there was no lights, it was very difficult to see, something happened far away. It'd be hard for anybody to have accurately seen under those conditions, or there was a really bright flash of lightning that affected their vision, or there was thunder affecting their ability to hear, right? Anything that might inhibit somebody's ability to observe, recall, or relate information accurately is attacking their credibility through sensory defects. And the rule here is very easy, right? Generally, and there is, again, this is not in the federal rules of evidence, so we don't have a hard and fast black letter rule here to refer to. But really, we're going to say that sensory defects, attacking a witness's credibility through sensory defects, is generally admissible, subject to a 403 balancing test, right? Generally, we don't have any foundational requirements to bring in extrinsic evidence, but we do say it's going to be subject to that 403 balancing test. Remember, we've talked about this a lot at this point. That's just weighing the probative value of the evidence against the danger of unfair prejudice to the jury. Remember, this is that typical or classic 403 balancing test, whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice to the jury, right? And if we have no 403 balancing test issues, right, it meets that, which remember the judge is going to decide, then we're going to allow sensory defects to come in to attack a witness's credibility. It's a pretty easy rule. Sensory defects, anything that relates to a witness's ability to observe, recall, or relate information accurately really is just going to be admissible, subject to a 403 balancing test, okay? That's sensory defects and bias, which is really, again, coming from the case law. When we get to prior inconsistent statements and untruthful character, fortunately, we do have federal rules of evidence that relate to these two methods of impeachment, right? Prior inconsistent statements, we have Rule 613 of the Federal Rules of Evidence. Of course, prior inconsistent statements is the classic, your story has changed, right? You said one thing 6 months ago, now we've gotten to trial, your story has changed, right? We have prior inconsistent statements. We're attacking the witness's credibility through this narrative changing, through their prior inconsistent statements, okay? And again, the first thing we want to think about with prior inconsistent statements, okay, is what is the source, right? Is this extrinsic or not extrinsic evidence, right? Because again, with prior inconsistent statements, we do have a foundation requirement to bring in extrinsic evidence of prior inconsistent statements with a little nuance, right? So we can talk about it though. Extrinsic evidence of a witness's prior inconsistent statement is admissible if the witness is given an opportunity to explain or deny the prior inconsistent statement before or after the prior inconsistent statement is admitted, right? This is a very key nuance to Rule 613, right? So remember, here we're going to require that a foundation be laid to bring in extrinsic evidence of a witness's prior inconsistent statement. But the key to recognize here is that the opportunity, right, the witness whose credibility we're attacking with this prior inconsistent statement has to be given the opportunity to explain or deny the prior inconsistent statement, but that could happen after the prior inconsistent statement is admitted. Right? Most of the time when we're talking about laying the foundation, it usually means we have to cross-examine this witness and ask them about this credibility issue right there on cross-examination to lay the foundation. Rule 613 doesn't necessarily require this to lay a proper foundation because we can do it after, right? As long as the witness who's being attacked on this prior inconsistent statement is given the opportunity to explain or deny the prior inconsistent statement at any time during the trial process, you're good to go, right? And we also have the requirement that the opposing party can examine the witness about it. That would almost always be satisfied. Very rarely that you're not going to see that, right? So long as that witness is going to be subject to cross-examination when they do have that admitted, right? Then you're good to go. But the real key to recognize here under Rule 613 is if we're going to bring in extrinsic evidence, you can do that. You can bring in extrinsic evidence to show this prior inconsistent statement to attack a witness's credibility at any time, right? So long as at any time the witness who's having their credibility attacked is given the opportunity to explain or deny the prior inconsistent statement. Now we do have one really important exception to note here, and we don't want to get too deep into a discussion of hearsay. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.